Next case on the docket is DCF versus J.J.E.
May it please the Court, I'm Ralph McMurphy for the Department of Children and Families. And
Mr. McMurphy, let me ask you, sir, I don't see anything in your brief where the department has challenged the finding by the lower court that the search was not a diligent one. Is that correct? You don't argue as a point on appeal that the trial judge erred in finding that it was not a diligent search.
the position of the department was that the trial court erred by going back and retrying the issues that had already been decided.
I know what your position is. I read your brief. What I'm trying to ascertain is, does the department take the position that his finding that it was not a diligent search was error?
Yes.
That particular finding.
Based on the facts as known to the department at the time, not 4 years later, but at the time that Judge Neal approved the diligent search.
So you think that the inquiry ends with the judge that approved the publication? That there's no you can't collaterally attack that finding. Is that your position?
You can through an appeal to this court or to another day.
How do you appeal? In other words, here's the situation. The department obtains, in an ex parte manner, they go in and obtain permission to publish. They can file an affidavit which is wholly conclusory. In other words, all it has to do is track the language of the statute. Say that we swear we did a diligent search. They don't have to say what they did or what they didn't do or anything like that. So they do that. They get permission to publish. How does the party who is not aware of the proceedings bring a direct appeal?
Petitions for a belated appeal.
Petition for a belated appeal.
Yes,
that's
it.
It.
Was not done in this case.
There's no basis when service of process is ineffective because it's contrary to the statute. There's no way that a litigant can collaterally attack that judgment.
Yes, the rules authorize that. Rules of juvenile procedure authorize that for a motion for relief from judgment.
All right. How about the Constitution? I mean, does that authorize, if there's no due process notice of a proceeding, does the Constitution authorize a collateral attack on a judgment? You know what a collateral attack is.
Yes.
Right? Is that certainly something that's authorized?
Yes, and the procedure for that in dependency case is under Rule 8.270B for a motion for relief from judgment based on a void judgment.
And that's what they did here, right?
Ultimately.
Okay. And the trial judge heard the evidence and decided that the department had not engaged in a diligent search. Do you take issue with that factual finding?
Yes, I do, because it was based on a predecessor judge, based on a successor judge, reinterpreting the evidence and the credibility of the witnesses and
okay, well, let me stop you there, okay? Judge Neal never made an inquiry as to what the factual basis was for the conclusory affidavit filed by the department, right? I mean, that's not his function, right? You file an affidavit, you track the language of the statute, you're entitled to publication at that point. The Judge Neal didn't hear what the evidence was that supported the conclusions of the department, right?
Judge Neal was aware that the department took the position that without further information, such as a social security number or date of birth, that the father's name was too common in order to be able to conduct a diligent search, a complete diligent search. The caseworker had tried to do a search through driver's license records and things.
But Judge Neal didn't have a hearing as to whether the department had in fact conducted a
It
diligence.
came up during the course of a review hearing.
Okay.
And,
But that's just an ex parte proceeding, right? That's not
No.
an adversary hearing, right?
Review hearings, GL is there and has an opportunity to ask questions.
Well, the appellate wasn't there, right?
No, the appellant
Appellate
wasn't there.
didn't have an opportunity to question the diligence with which the department looked for him, right? I mean, he's not there, right? But doesn't he have the right at some point in time to come into court and challenge the department's conclusory affidavit?
He can come and challenge it, but it should have been before Judge Neal. Judge Neal.
Why would that be? Have you read Paladin Properties versus Family Investment Enterprises that was in the last advance sheet?
I'm sorry.
Well, here, in that case, the second district says, the Florida Supreme Court has held that a successor judge may revisit a final judgment entered by a predecessor judge when there is a motion filed pursuant to, in this case, Civil Rule 1.540, functional equivalent of the rule used here. This is so because a legally sufficient 1.540 motion by definition entails matters which, at least ordinarily, were not presented to or considered by the predecessor judge. That's exactly the situation we have here.
Well, I believe that it was
Let me ask you another question.
issue of whether or not the department had conducted a diligent search based on the information that was available to it at the time was considered and ruled upon by Judge Neal.
The problem is the information available to it was information that there was never an effort to go out and find any information. It took the barest minimum information given by the mother, who even the department felt was perhaps not candid, and then they ignored going next door to the Department of Revenue, which had all the information they needed right there.
But, Your Honor, the caseworker testified that they didn't go to the department because they won't release any information without some further identifying information other than just a name.
Have you read J.M. versus Department of Children and Families? That's a case that Judge Thorpe authored last year.
Yes, I read that, and
Why doesn't that case end it here?
because the facts were considerably different in that case, considerably different. In that case, the mother had registered a permanent mailing address with the court, and the department knew where she worked. In this case, the only thing that we knew about this individual was that the mother said he was either in New Jersey or Orlando. We knew his name. That was it.
Let me get you back to your 2 points on appeal. Your first point is that a successor judge did not have the authority to hear the motion. Is that right? I mean, you've acknowledged that a party has a right to file a motion to set aside a judgment if service of process was not proper. You acknowledge that, right?
Yes.
Okay. What are you saying? Is that they should have set that motion for hearing in front of Judge Neal?
Yes, because
Whether he was the dependency judge or not?
yes, he was still on the bench.
Supposing he wasn't on a bench anymore, supposing that he was either retired or he was deceased, then what happens?
I still think that in this case, what happened was that Judge Tombrink, as the successor judge, went back, took new evidence on matters not known at the time to the department, and even considered what the use of the internet as it is in 2006, when there was no evidence of what was available on the internet in 2002, other than the
Mr. McMurphy, I'm sorry, I hate to interrupt you, but I don't think you answered my question. What would have happened if Judge Neal wasn't on the bench anymore? Who hears this motion that they filed? You said they have a right to file it.
Dependency judge, but the dependency judge would not be able to go back and make a new ruling based on new facts and evidence that was not before the prior judge, and on situations, matters unknown to the department in 2002.
Well, the point of the inquiry, and I think the case that Judge Monaco cited, J.M., says this, is that since the department has the right to file an affidavit which simply states we have done a diligent search, and they don't have to say what they did or what they didn't do, that the litigant has a right to challenge that conclusion by having an evidentiary hearing. Am I right so far?
Yes, Jim.
Okay. And so isn't that what Judge what's his name? Tombrink. Isn't that what he did? He had a hearing to decide whether or not you all had in fact been diligent.
Yes, but in doing so, he did it on the basis of not what was before Judge Neal, or what was known to the department in 2002, or what was available to the department in 2002. He did it on the basis of what was known in 2006.
So the department's only obligation when it's charged with the responsibility for making a diligent search is to only look at what it has in its possession. They don't have any obligation to search for the party?
What is known or reasonably available at the time to the department.
Well, this fella ran a driver's license check, and he found out there were 7 people in Florida with the same name as the appellant. Now, why didn't he try to figure out which of the 7 was the appellant?
How they're supposed to do that? Call each of them up and say, "Are you the one who has a dependent child?" You can't do that.
How about getting a copy of the 7 driver's licenses from the Department of Motor Vehicle and taking the pictures to people that know the appellant and asking them which one is him? Just for one. I mean, I'm no diligent searcher, but what's wrong with that? I mean, this fellow did nothing. He said, "I haven't got a Social Security number, and I haven't got a date of birth because the mother didn't supply it or the caseworker didn't supply it. So there's nothing I can do." He threw his hands up and he said, "There's nothing I can do." Right?
Well, he did try. He tried to do a search using a nationwide search on the internet and got nothing. He did a search of the driver's license records, got 7
names. What happens if he had gotten 2 names? Would he have just said, "Well, there's 2 names. I don't know which is which"? So that's it. My inquiry ends there. Is that a diligent search?
No, not if there was some way of trying to narrow down those, if it's just 2. But the whole issue is what is reasonable. And Judge Neal found that it was reasonable.
Judge Neal didn't even know what he had done. Right? I mean, I don't see anything in the record where the actual facts were before Judge Neal. the lawyer said, you know, Judge, we filed an affidavit. It's not even clear that Judge Neal had read the affidavit. You know, he made some reference to the fact that it wasn't in the file. And Judge Neal said, okay, go ahead and serve him by publication, right? I mean, he didn't know whether the guy had made any attempts to find that time, right? I guess that's a question.
I'm not sure on that. But Judge Neal had been the judge who had been on the case and knew what had been going on in the case all along. He knew that this mother was not being cooperative and may not have known the truth if it jumped up and bit her, but and that we didn't have a whole lot of information to go on in order to be able to do a diligent search.
You're down under 4 minutes if you want to save it for rebuttal.
I reserve that for rebuttal.
May it please the court, counsel, my name is Gary Gossett from Sebring. It's my great pleasure, along with my newly admitted to the Bar Associate, Mr. Christopher Cloud, to represent J.J.E., who is present here in the courtroom today. Perhaps what separates...
He was indicating to me at the break that he thought he wanted to do the oral argument. Why don't you let him do the oral argument?
Very well, Your Honor.
Unless he's wearing one of those astronaut diapers, it's probably a bad idea.
Mr. Cloud was a great help in drafting a appellee's brief. Always appreciate the sharp minds of recent law school graduates. But perhaps what separates us the most from the other nations of the world, even those that espouse to embrace democracy, is a due process clause. As a combat veteran of Florida Army National Guard, one of the greatest things I appreciated as a second-year law student when I returned from a fairly dangerous military assignment in Panama.
Counselor, is your history as a military participant at all relevant to this process?
Well,
it's in evidence at all?
It's not, Your Honor. It's an introduction. Very well, Your Honor. The due process clause is what distinguishes the United States and the state of Florida, because it also embraces a due process clause, from the other nations of the world, even nations such as Great Britain that espouse democracy or embrace democracy. Because our constitutional freedoms outlined both enumerated directly in the Constitution and by the various cases that are presented by or that are issued by both the state and the United States Supreme Court. Due process means that a constitutional right has a redress. And it's very clear in this particular case that my client, J.J.E., did not receive due process. His constitutional rights to a very protected fundamental liberty interests, those interests that are protected most by the Constitution, were violated because he did not receive notice of any sort of proceeding against him by the state of Florida. His testimony below, and what the record does reflect, was that he did not receive direct personal service of process in either dependency case or determination of criminal rights case. What the record is abundantly clear on, and I believe as the court has pointed out, is that he additionally did not receive constructive service of process, which is a last resort when a sacred fundamental liberty interest such as a parent-child relationship is at stake. It's such a last resort that both the United States Supreme Court and the Florida Supreme Court have stated that in such cases that a service by publication statute must be followed to the letter. In this particular case, what the dependency court should have done in January 2002 was direct and order that a diligent search be conducted. And this goes to, I believe, Judge Torpey's question. Under Section 39.803, 5 and 6, if a parent cannot be located in a termination of criminal rights proceeding, then the court must direct the department to conduct a diligent search. And as a minimum, that diligent search will include different things, but certainly most importantly is an inquiry of other state and federal agencies likely to have information about the unknown parent.
Judge Neal, it wasn't even his job to go behind the affidavit, right? Once they file the affidavit, they have the right to file a conclusory affidavit. Doesn't have to say what they did or what they didn't do. And then, as long as the affidavit's in the file and it tracks the language of the statute, then, barring some challenge to the affidavit, which your client ultimately made, then the trial judge doesn't have any responsibility to affirmatively ask them what they did and what they didn't do, right?
Your Honor, I think under 39.803, 5 and 6, what the statute says is the court shall direct that diligent search be performed. And I believe that the dependency court should have done that.
That's on the front end.
That's on the front end.
The court directs that it's done, but the court is not responsible to police the actions of the department to determine whether they followed that direction, right?
The statute doesn't speak to that, Judge. I
mean,
believe
it doesn't happen. I mean, you know the way these things are conducted.
That's right, Judge.
Constructive service of process, whether it's in a termination case or a civil case, is done outside of the court's presence, and it culminates in some conclusory affidavit that the court reviews for legal sufficiency. And beyond that, it's not the function of the trial judge to go beyond it. Is that right?
Your Honor, the appellee would concede that that's how it's done. In fact, the trial court ultimately, in time, becomes to rely on the representations of the department that there must be, if there's a facade, there must be something behind it.
So the remedy that is available to someone in the situation of your client, when they finally find out that they've been involved in this legal proceeding, is to do exactly what your client did, which is file a motion to challenge the judgment. Right?
That's correct, Your Honor. In this particular case, and it's sort of an anomaly, and so far I can't tell that this court in the prior prohibition proceeding or even the trial court really appreciated this issue, but there's no way that a parent that's in the shoes of J.J.E. can actually determine whether it's a dependency case or a TPR case, because once that TPR order is entered, everything sealed is confidential. So in reality, what we had to do as a practical matter was to proceed to the great writ, to the writ of habeas corpus, and essentially punt, because according to various newspaper accounts, that there was some type of legal proceeding in that court that involved J.J.E.'s son, J.E. So as far as just running into the dependency court and filing a motion pursuant to 8.270, you can't do that. J.J.E. couldn't do that because he didn't even know if there was such a proceeding, and the clerk wouldn't provide it.
But you eventually got there.
We got there.
The judge heard the evidence.
That's correct.
And he made a finding that they had not done a diligent search, and he made a finding that you had filed the motion in a timely manner within a reasonable time, and those findings are not challenged on appeal, right?
I think that, in all candor to the court, that the appellants, the department's second issue was whether or not the motion had been filed in a timely manner. The finding of fact by the lower court was that it was, but I do...
My next question, is that a question of fact or a question of law?
Whether it was timely, it would be a mixed question of fact and law, I believe, Your Honor. The law end would be the standard, and there's no real set in stone standard, but we have a broad doctrine called latches that would provide, perhaps speak to that. But what the court did find as a finding of fact was that as soon as Mr. Edwards learned of potentially this case and his son's whereabouts through the media accounts, that he filed his verified petition for writ of habeas corpus. So I believe that the appellant did raise that issue to answer the court's question. We don't believe that that's meritorious, and that especially because of finding a fact at the trial court, and finding a fact is not challenged. There's no fact that the appellant looks to say that it was untimely. He does speak to it in his brief about foster care issue in 1998. There's nothing in the record to show that my client in any way knew that there was a foster care case, a dependency case, against him and his son in 1998. In fact, what the record shows was the children were released from foster care in May of 1999, and the court terminated its supervision of the children. And then another dependency case was later filed that led to the TPR, and that's in the record before the court. Clearly, it's a simple case. Due process requires notice. My client never got actual notice. If he never got actual notice, the constructive service statute must be followed to the letter. Here in this particular case, they clearly were not. And I believe that the court's pointed out the operative facts to that prior to that. So it's been my great pleasure representing J.J.E. and subject to further questions by the court, would relinquish the podium to counsel.
Thank you, counsel.
Just briefly, this is a case where a father who has a natural responsibility for a child knew in 1998 that that child had been placed in foster care and did nothing to try to find out where his child was, what was happening to him, or to pay any kind of support for him for 6 years until he sees something in the newspaper. If he was so interested in his child, or even wanted to perform the merest of parental duties, all he had to do was to contact the courthouse in Hernando County. He had the advantage of knowing where the children were, where the case was pending in Hernando County. The department did not have the advantage of knowing where he was, so they could go check with like local police or the utility companies.
Does that excuse the department, Mr. McMurphy, from conducting the diligence search?
No.
That the father's been negligent, or not been diligent in searching for his child, or not provided support or anything like that?
No, but it doesn't excuse it, but it is, I think, a factor to be taken into consideration by the trial court, and Judge Neal was aware of the situation that this man had not come forward in at that point, it was 2002, it was about 4 years, and that he had so little interest that he had not given any indication to the department, the court, or anybody else where he might be, so that we could actually try to find him and get him into court. And that was one of the factors that Judge Neal was entitled to consider in whether the department had conducted a proper investigation. And Mr. Gossett made an argument on the basis of due process, but that is a matter that can be waived if it's not pursued on a timely basis. This man had since 1998 to try to find out what was going on with his son, but he waited until 2004 and then until 2006 to go to the proper court. And the department's position is that is not timely. That is not within a reasonable time.
Is the question of whether he brought the motion within a reasonable time, is that a question of law or a question of fact?
Again, I would have to agree it's a mixed question of law and fact, because you have to look at the particular facts of the situation.
What is your standard of review on that issue? What is our standard of review? I'm sorry. Use of discretion as to the fact finding, is that right?
Yes.
And you think you've demonstrated an abuse of discretion? I'm sorry, do you think you've demonstrated an abuse of discretion by the trial judge?
Well, on the facts of this case, yes, because the judge actually did not, in the order, make any specific findings regarding, I find this motion was brought within a reasonable time. And that it is, and that, made no specific findings with regard to that. Just made a finding that they filed the habeas corpus petition in 2004. And the trial judge was actually required in the dependency rules to make specific findings in an order that, yes, this was brought in a reasonable time, and the judge didn't do it.
Thank you, counsel. Your time is up.
Thank you.